So we're going to head straight into the next session. For those who are just joining us now, a reminder that the event is being live streamed on the Melbourne Law School's YouTube channel. It's being recorded and will be posted on the university's website soon after it concludes. So I would like to reintroduce Dr. Genevieve House, Coordinator of Health Law and Ethics Unit at WHO Wipro, for session 2, which is on the role of public health and health emergency laws during COVID-19 and opportunities for strengthening. Thanks, Genevieve.
Thanks so much, Jonathan. Good morning, good afternoon and good evening to everybody, and a warm welcome to session 2, the role of public health and health emergency laws during COVID-19 and opportunities for strengthening. When we think about law and COVID-19, depending on our own experience and the country we're in for the past 18 months, very different things may spring to mind. Our region is so diverse and no country began with the same law or used their laws in the same way. In my brief opening comments, I'd like to reflect on some of the many ways that laws were used in the COVID-19 response, and drawing on and perhaps adding to some of the comments that Jonathan made, because it's a very neat pathway from those comments into this session. Across our region and globally, there was great variation, but I will touch on some broad themes. The basic health function of surveillance, so the ability to detect, test, isolate and treat every case, and to trace and quarantine contacts based on public health advice. Most countries have laws which support this kind of activity. Restricting movement. COVID-19 is highly infectious and some variants are even more infectious. To mitigate or prevent transmission, many laws enable imposition of rules on behaviour that restrict the free movement of people and their use of public spaces. And some of these can impose restrictions on people's human rights. Most people use laws to impose measures to manage the public health risks at points of entry, restricting entry or seeking information from arrivals, requiring testing, the imposition of quarantine. Some countries use laws to support the collection, reporting and use of health information and data, a vital function during an epidemic. Some laws also impose requirements for protection and privacy of information based on human rights principles. Many countries observed an increased need for medical equipment and supplies, vaccines and the like. Laws were used to help address this. For example, prescription extensions that encourage people to stay home. The alteration of statutory requirements about government procurement to enable swift emergency procurement of necessary drugs, medical supplies, vaccines, and so on. Emergency laws and orders may also restrict broad availability of some drugs to ensure quantities needed to treat COVID-19. Some laws ensure the safety, quality, and efficacy of drugs and medical products. Legislation may enable telehealth and other uses of technology, but these will be covered in session 3. Emergency temporary or emergency registration of health workers was enabled by some countries through law. Others provided for limited expansion of the scope of practice of some health workers to enable task sharing between cohorts, such as medical practitioners or nurses, or task shifting, for example, from nurses to community health workers to make the best possible use of the available workforce across a country. For some countries, laws were used to involve the private sector in emergency response efforts, as Jonathan said, a crucial way to expand capacity. For example, to increase available system capacity, including available hospital and health facilities and services such as laboratories. This was done quite differently across different countries. A few examples include by contracting, by emergency order, or the use of tax incentives. Laws were used to protect human rights and to protect those disproportionately affected by the health measures that were imposed. Many countries have ratified the international human rights conventions and variations, mixes of these, and have a legal obligation to give them effect when they've been ratified. Many countries also have human rights protections in their constitutions and other laws that would have and did have application in all COVID-19 responses. Ensuring the availability of accurate and reliable information on the emergency to the public was a challenge for many. Some countries conferred responsibility via statute or by administrative means on a senior official to be the one source of formal information delivery to try to communicate more clearly with the public. In an age of swift transmission of information via social media and other informal means, it can become a complex exercise to communicate clearly and effectively. Some countries designated the spread of false information as an offence. Laws were used to attempt to ease the financial burden of the COVID-19 crisis in the form of mandating payments for workers who couldn't attend work, the provision of rent relief, or other kinds of benefits. Laws were also used to try to safeguard the rule of law during COVID-19. For example, in some countries, laws were altered to allow parliaments to sit remotely, or courts also to sit remotely, or to undertake the different use of rules to allow them to continue under the altered circumstances. These are just a few examples of how laws were used during COVID-19. We're learning all the time, and as we've heard in the introductory remarks, that is in fact the purposes of our forum. In our panel, we're going to hear from 6 experts who will provide their wisdom, their unique perspective in a 10-minute presentation each, and then contribute in the open discussion. And so I'd now like to introduce our panelists for this session. Mr. Mapo Fazu, the Disaster Law and Advocacy Manager, Pacific International Federation of Red Cross and Red Crescent Societies. Mr. Bel Kama, Department of Pacific Affairs, Australian National University. Mr. Bob Williams, Secretary of Health, the Cook Islands. Sorry, we've just lost my again. Mr. Bob Williams, yes, Secretary of Health, Cook Islands. Ms. Mandy Charlton, Director, Border Health, Department of Health, Australia. Dr. Pozikai Samuel Tapo, the Director of Corporate Services, Policy and Planning, Ministry of Health, Vanuatu. And Dr. Lu Yang, Legislation Department, National Health Commission, China. And perhaps what we might do is go to Dr. Bel Kama. Dr. Kama, are you with us? They're from the Department of Pacific Affairs, Australian National University.
Thank you, Genevieve. Hello, everyone. And thank you for the opportunity to be part of this very important forum at a very significant time, I think, of human history, in that, you know, the whole world is confronted with something that it is perhaps hasn't seen in a long time. And it has shocked systems, institutions, and people. And especially for vulnerable societies, I think the COVID pandemic has really a huge set of impact on them. And one of the areas that is quite critical, of course, is the subject of our talk today, which is the legal framework. How do we govern such, and when we are governing it, what kind of considerations do we take into account? And my observations will be based on some of the countries in the Pacific Islands that I have observed. And obviously, I haven't observed all the 14 countries in the region, so I am definitely open to also learning from others in these discussions that will follow from this conversation. And of course, from other countries in the region that the WHO Western Pacific covers. So my observations, especially on, and I will talk, trying to cover the 4 questions that are being guided, which I think are really good in guiding such a talk. So I will try to cover them as I speak broadly on it, and then hopefully discuss more when we come to the question time. So my observations based on Papua New Guinea, Fiji, and Solomon Islands, especially concerning the first question, where to what extent have legal frameworks for public health and health emergencies supported an effective COVID-19 response, and what are the challenges and limitations? Observations from these countries, and obviously I am choosing those countries, Papua New Guinea, Fiji, and Solomon Islands, because they are comparatively the 3 larger states in the Pacific Islands. And some of their messes were quite quite much more extensive compared to the other smaller states. So looking at those three states, they were initially using the powers within the Constitution regarding the emergency laws, and then eventually bringing other laws and regulations to monitor and continue to administer COVID-19 measures. But the initial use of the emergency powers gave rise to a lot of concern, obviously, because the emergency powers in these countries have give sweeping access to the controllers of the powers, and it raises concerns about to what extent, or where is the balance between that and the human rights of the people. And they were at least, the sense of effectiveness, the fact that the situation was serious and it demands a serious approach, the use of emergency powers give that picture of how serious COVID-19 was, or when it first entered these countries. But I think there are some sort of insights that we can gauge from how, say, countries like PNG and Solomon Islands kind of approach those powers. And in terms of Papua New Guinea, it did use the emergency powers, but then decided to use the Pandemic Act to manage the ongoing management and the administration and to coordinate COVID. Whereas in Solomon Islands, they decide to continually use the emergency powers and place a larger sort of reliance on that. And as you can see, or you may have heard, last year there was about 8 months of lockdown, nationwide lockdown in Solomon Islands, and this year there was about 4 months of lockdown as well, again based on constitutional powers. That raises significant concerns about certain limitations on human rights for that extent. PNG decided not to, because one of the main reasons between, say, Solomon Islands and PNG in not using constitutional powers, but using Pandemic Act in the case of Papua New Guinea, is that when those countries with emergency laws, there was a lot of scrutiny that is expected, say, in Papua New Guinea, where the person managing the emergency powers has to report directly to Parliament and seeks Parliament exclusive approval to continue that emergency powers, whereas that is not required under Pandemic Act. So bringing in Pandemic Act was a way to get around that very very tight sort of scrutiny, and obviously, that also means that pandemic sort of response doesn't need to be subject to too much politics. Obviously, Pandemic Act allows for a much more swifter response, but it does raise the question about accountability. Emergency powers that implicates on rights, that's only accountable to the executive government, to the cabinet, and not to Parliament, raises questions in Papua New Guinea. Whereas in Solomon Islands, for instance, there is a lesser kind of accountability framework around the emergency powers, in terms of there is no firm expectations provided for you to be reported to Parliament. There is while the emergency powers provide for a broader scope of powers, doesn't on the same level provide for a great accountability. So obviously the government prefers that to be a better option than having a separate legislation guiding the powers used to effect COVID-19 response. Now, there are three sort of challenges which I'd like to quickly get into. Firstly, I think the use of emergency health laws in the Pacific countries generally raises the question about human rights, and many, in fact, all of the Pacific states have certain Bill of Rights within their constitution, and so that is a ongoing concern, and especially the use of police and military in trying to impose the emergency laws, and that brings to the second challenge is how prepared are these enforcement bodies? I mean, when it comes to enforcement that is led by police and defense, they are perceived as, punitive. They are the agents of a legitimate state violence. Now, how do you change that job description in a pandemic setting where there's a lot of social distress, there's a lot of need for empathy, and how do you change the role of police and defense force who are perceived as agents of state violence, or agents who are more akin to more, punishment-oriented kind of work, to now have that new sort of role. And I think that's a struggle that speaks to the level of training that maybe the police and the defense force may be having as well. I mean, how much of their training take into account situations where they will be able to lead in, say, pandemic settings, where there is a lot of social distress and a need for more, much more empathy as well as enforcement. The other thing that the challenge of the enforcement part is that many of the law enforcement agencies in the Pacific do not have proper counseling systems set up within the enforcement. So they don't have a service for debriefing and their own mental health. Those things needs to be really taken a closer look at. I should probably just run to the there's another point that I would like to raise for our consideration, is about the consistency of policy between government. Yesterday, for instance, Papua New Guinea, one of the largest mining firms, there are about over 1,000 mining workers that have been reported to actually resign because they don't want to have they don't want to have vaccination. While the government doesn't have a strong position or doesn't have a firm position on whether or not vaccination is a mandatory thing, it allows private entities to actually mandate that. I think there is a gap there in terms of legal and policy consistency, leaving it for private entities to decide on methods that have larger social implications. I think there needs to be thinking around that as well, in that, does government emergency powers reach out and also decide on policy methods that concern private entities and what they should and shouldn't be doing. And that is obviously a concern for Papua New Guinea in the last couple of weeks. There's a lot of protests around that as well. Now, one of the major issue that I think government will be facing going forward in terms of looking into the future is that the social media, many of the governments in the countries that I've looked at have raised serious concerns about the use of social media in trying to undermine government messaging. And they're thinking of how do we kind of limit that. But again, it does raise the question about, does the need to have stronger public health emergency laws and ensure that there is success in that regard include suppression of certain rights that are perhaps fundamental to having a balanced view about things. And media, for instance, is something that some of the governments are also considering, and whether that is a much more reasonable approach to dealing with something like pandemic. The other things that perhaps can speak to WHO and many other external entities is the influence from the influence of external bodies on internal policy making, and there are concerns being raised about, is it constitutional to allow external entities having a greater say in how local policies and laws are being designed. And I think these are some of the things that speak to the minds of Pacific states, which I've come across. Now, I will finish off with, there are some major court cases that are currently on foot in Fiji and Papua New Guinea, or talks about bringing cases where things like no jab, no job policy, or the PNG courts, for instance, is now imposing no jab, no entry to the court, meaning that it's denying lawyers and litigants to enter court if they don't have jabs.
Dr. Kama, please wrap up as soon as you can. Thank you.
Sure. So I think, for instance, that PNG case raises questions which speak to the fourth issue about, or the question about the implications of certain approaches to the rule of law. Incidents or policies like no jab, no entry to the court can have greater implications on the state of rule of law. If we don't give access to litigants to come to court because they don't have jabs, then it does raises questions about to what extent does it abide to the need for rule of law to actually function still in the society if litigants decide not to get jabbed, and thus court refuse them that sort of access. So anyway, I will leave some of these thoughts here, and I will open to answering some of your questions. Thank you.
Thank you so much, Dr. Kama. That was really interesting, and I think the issue of accountability, the issue of respect for constitutional oversight and enabling that oversight, and the effect of laws that perhaps to some extent go around that oversight, very interesting, and also that oversight, the importance of it in the very broad-reaching health measures that are being undertaken, touching all aspects of people's lives. So thank you very much for those comments. And also, we will also be watching with great interest those court cases that you mentioned, and to see how the courts deal with some of these very important issues. I'd like to move on now. I'd ask you to perhaps keep your questions until all the speakers have spoken. So just jot down questions that you might have for Dr. Kama and other speakers as you go, and then we'll open it up to questions at the end. So I'd like to introduce now Mr. Bob Williams, who's the Secretary for Health in the Cook Islands. Over to you, Mr. Williams.
Thank you, Jeannie. A warm greetings and kia ora to everyone who have joined us on this meeting. The topic that we are discussing today is timely, especially for us here in the Cook Islands. Our cabinet this morning has approved for our new border settings. And of course, strengthening recall preparedness and future response is critical as we watch our countries, nearby countries, the like of New Zealand, Australia, and others, who are moving away from the elimination strategies and moving towards suppression strategies, which is also critical for us here in the Cook Islands. So with the new norm, as we progress from the early of next year, that our journey for COVID-safe Cook Islands will be the new direction for us here in the Cook Islands. And of course, we have identified gaps with the Public Health Act and also our international health regulations, which led the government to pass a COVID Act in March of 2020 to address some of the gaps with regards to contact tracing requirements, quarantine of travelers and individuals, wearing of masks, and other requirements that is required to ensure the safety of our people in the Cook Islands and those coming from overseas. So today I'm happy to present the Cook Islands experience with the role of public health and also other agencies, key agencies that are involved in our national response to ensure that we continue to be COVID-free. So the Cook Islands was declared as a COVID-free nation on the 16th of April of 2020. And up to this stage, what the forward future for us will be starting to learn how to live with the virus, similar with the trends of other countries that are now embarking on. And with the new border setting from earlier next year, so there will be an amendment. Our Crown Law Office will be submitting to Parliament before end of the year for the necessary changes to take place before opening our border early next year. So our success since over the last 18 months has been under three main points. One, of course, is strong leadership, including our three main pillars here in the country, the government, and of course our traditional leaders, our religious leaders, to take the lead in terms of ensuring that the whole community complies with the requirements of the COVID Act and public health measures that have been put in place since last year and up to now. And secondly, strong public health measures that we've been putting in place with contact tracing and of course wearing of masks where required, and also the framework that we have put in place. We have suspended our border requirements several times. We engaged with New Zealand for a one-way quarantine-free travel in January of last year, and up to May this year, we have been having a two-way quarantine with New Zealand. And because of the COVID situations in New Zealand, so we have suspended several times of our two-way quarantine-free travel. And for the current Delta outbreak in New Zealand, our border has been closed for almost 9 weeks, up to now going on to 12 weeks. So including in the COVID Act is enforcement actions to support our preventative measures and also ministerial orders to ensure that people comply with the requirements when they are put into self-isolation or into a supervised or managed quarantine. Since then, we have charged 2 individuals under the COVID Act. One relates to providing false information to the Ministry of Health, and secondly, as of recently, as of last week, one is now facing charge for breach of the quarantine orders. Because we have brought back 2 cohorts through repatriation flights over the last 3 weeks, and also as we prepare for another 2 managed returns for the coming month, for this month of November and 1 in December. There's been multi-sectoral support and response. One thing that we've stood up is we call it a PUNA system. PUNA system is we have several districts on the main island of Rarotonga here in the Cook Islands, where we have linked with the emergency management framework. So the Ministry of Health has worked closely with emergency management Cook Islands to stand up these systems and infrastructures to provide support for our communities within those districts. This will become very important for our new border setting, because should there be a positive case in the household, the whole household will be quarantined, and the support from this border system will be very important to provide moral support and other needs that is required for a particular household. And similarly to tourism, to visitors, when we open our borders early next year, the same process will be applied. So there will be a lot of sectoral approach, which will include our tourism sector and our business sectors with the requirements that needs to be implemented across the whole sectors of our community. So with the current legal frameworks in place, as I mentioned, our Public Health Act, while it provides for the quarantine of ships and vessels and aircrafts, including passengers or crew. But what has happened is, as of this year, the COVID-19 Maritime Water Regulations 2021 was enacted. This is to allow, while our borders closed to vessels, but the regulation provides for exemptions to be provided. Example, like cargo vessels that needs to come into the country to bring in cargoes, or emergency flights that needs to come into the country for transit and go into another country, and likewise for other small vessels during cases of emergencies. But there is limitations to the current act, and I would like to acknowledge Ben, Larry, and Dr. Chris Reynolds, who have also contributed to the development of our new public health bill. With regards to the Ministry of Health Act, it does provide for powers of entry, inspection, seizure, and contain drinking conditions. But the Act also has an overarching functions and responsibilities of enforcement, with the inclusion of police powers. But it is difficult to apply these powers in practice. So the enforcement powers provided under the COVID Act has been clearly outlined to allow our police officers to support our Ministry of Health in terms of responding to COVID breaches under the COVID Act. But the problem with the COVID Act is it's only valid for 6 months, and it has to be extended every 6 months. So with the new Public Act, Health Act coming into force, maybe in end of next year, that will override the existing COVID Act requirements. The International Health Compliance Regulations, while it does provide specific arrangements for implementation, providing power to the Secretary to develop implementation plans, which we are also at the moment developing a pandemic response plan. COVID-19 has taught us a lesson that some of the plans that we had previously needs to be updated and revised to ensure that it captures not only for COVID pandemic outbreaks, for other future pandemic outbreaks that will be expected to come in the near future. And of course, the limitation is that the scope of the international health regulations and their relationship to other legislations and regulations is often unclear. And of course, it limits its practical usefulness when it comes to implementation. So the COVID Act, as I mentioned earlier, was developed in March 2020, it is time bound. So that's why we are now proposing with the development of the new public health bill. So Ben Riley and Dr. Chris Reynolds has been supporting the Ministry of Health, and I'm glad that our cabinet as of last month has approved for the bill to continue to progress to the next stage, and the timeline for its completion is 12 months. So we're looking about December next year, 2022, for it to make its way to Parliament for enactment. And this will provide more enforcement powers and increasing penalties, and also to capture other health risks that needs to be captured, and also for future pandemic outbreaks that needs to be considered now. So the new law has these aims and objectives. It is outcome focused to address public health risks based on actual and potential harms, and the aim is to be a future-proof legislation that needs to look at health challenges over the coming years and decades, and of course, most importantly, is to protect our Cook Islands population from serious public health risks, and also to prevent acute support, health promotions, and the whole of society action on NCD. And it is planned to be inclusive, to include our communities, to be empowered to take part in decision making and also to protect and promote the health of the wider community. Yes, so finally, just like to acknowledge all the key partners that has been in support of the development of the public health bill. And of course, going forward, that will include all our national responses to future pandemic outbreaks. Thank you.
Thank you so much, Mr. Williams. And it really does, I think, assist everybody to walk a little while in your shoes and to see the different experiences from different countries, because we all learn so much from doing that. We're going to move on now to Dr. Posikai Samuel Tapo, who we didn't give his current title. He's the Acting Director General of the Ministry of Health Vanuatu, and we apologise for our error earlier. And over to you, Dr. Tapo.
Good afternoon and greetings from Vanuatu to all our colleagues in the Pacific and overseas. Thank you for giving Vanuatu this opportunity. I'm here in the room with the manager and the acting director for public health and the manager for disease surveillance and disaster within the country. So basically, I will run quickly into the questions that were put forward. And then from there, if there's any questions or any comments that colleagues want to raise, then they can ask it at a later date as per the remarks from the chair lady. Firstly, in regards to the public health emergency, the government of Vanuatu under the Public Health Act did an amendment to the Act and aligned it with the international health regulations. So there was the amendment CAP 234, which captures the declaration of a public health emergency that was not part of the Public Health Act that was amended in Parliament this year. And under the powers in the Public Health Act, it was more clear and more defined to isolation, for example, quarantine, giving penalties to those that breach quarantine and isolation, and also for the minister to issue regulatory orders to a specific agency in the event that we had to confine a ship, prevent plane from entering, or even confining or putting a group of people into isolation or quarantine. So it was limited to that area, but more clear and defined with the amendment of the Public Health Act. The Public Health Amendment Act was, as I mentioned earlier, was more aligned with the international health regulations. So in the event, not only for COVID-19, in the event that there is an increase in the threshold of a specific disease within country, then it signals a declaration of the Public Health Act, and then from there we respond. So it basically didn't only focus on COVID-19, but it also focused on other notifiable disease under the Public Health Act within country that can be declared as a public health emergency, and a response can be given. So within the Act, there are a few committees that the Act prescribes, the Amendment Act. That's members of the committee is chaired by the Director General, which is equivalent to the Secretary of Health in some countries. So he or she plays the chair. The members of the committee, the Director for National Disaster Management Office is the co-chair. The Director for Civil Aviation is a member. Director for Foreign Affairs is a member. The Commissioner for Labor, the Commissioner for Police, the Director for Immigration, the Director for Customs, and the Director for Maritime and Ports. So that's basically the core members. The other members are invited to the committee meetings per the request of the chair or from the committee. So that's basically all the committee members that make up the advisory to that. What happens is that during a discussion of that committee, they make recommendations to the Director of Public Health, who plays the secretariat to that committee, and the Director for Public Health then advises the minister, and the minister issues a regulatory order in terms of quarantine, issuing a fine, or issuing an instruction to an agency to take specific roles or functions during under the public health emergency. So I think that's basically in regards to the first question. The limitations that we have within the amendment is that it doesn't really prescribe the powers that we can use to to direct to police and other institutions. What we have seen also is that the National or DRM Act that we operate under, which is normally given to NDMO by the head of state or under the state of emergency, has more powers that can confine a specific group of people, at the same time give directions to police or the military to take specific actions. Under the Public Health Emergency, under the Public Health Act, we don't normally have such powers. So it is something that we've been struggling in the few months, whether we should continue with the Public Health Emergency or allow the response of the COVID-19 response or the pandemic to be under the SOE. So that is the limitations that we have. We are now exploring that through the state law office, just to see what powers the public health can also issue and can be equivalent in a way to the State of Emergency Act that is given to the NDMO. The NDMO Act doesn't really spell out this outbreak or this emergency. So we normally use their powers based on their control of an SOE in the country rather than a public health emergency. So it's a tricky area that we are trying to explore with our state law office to really draw a line in which powers the public health emergency can perform. At the same time, what powers or what powers are similar to what the state of emergency can give to the public health act. So I think that's the first one that we've been challenged with. Apart from that, we have managed to control the pandemic, and that's why we still have border cases with the support of the SOE and the public health emergency. The limitations going forward, as I mentioned earlier, we are trying our best to do a transition from the state of emergency, which is under the National Disaster Office, to the public health emergency. What the state law advises is that the public health emergency is more clear and that it can really spell out quarantine, isolation, if we are going to put people into quarantine, if we are going to prevent a flight because of a specific disease. It clearly spells it out compared to the SOE. What we are doing now is they're trying to really explore the powers that the Public Health Act can use in the event we have to control agencies, which that area is still yet to be explored compared to what the SOE can do. So I think that's the challenge or the limitations that we have under the Public Health Act. The government has decided that the SOE will come to an end at December 31st this year, and we will transition to the public health emergency. And during that time, it will be under the Ministry of Health leadership, and the minister will be the one that will be issuing regulatory orders. Today, it is still under the Disaster Office, which is headed by the Director for NDMO. Major lessons that we have learned. One classic example was when we wanted to conduct simulation exercise. The police could not participate. The police did not participate because they advised us that under our law, the public health emergency law, we could not instruct them, or it was not really clearly spelled out. So that is the challenge that we have right now. Even though we can declare a public health emergency, we still do not have much clarity in our law that can direct a specific agency like what the SOE under the Constitution does. It can direct a specific agency to do what, it can confine or stop a ship or stop an aircraft. But for public health, amendment public health act, it is not clear. So I think that is the major lessons that we have learned. We are thinking of going back to Parliament just to do an amendment to give more powers to the Public Health Act. Currently, the limitation is that the Public Health Act, under the minister's regulatory orders, can issue, but whether it has more weight to direct a particular agency to participate, or it can direct businesses to close their door, that power, compared to what the Constitution does under the SOE, we find it that the Public Health Act doesn't have much power. So I will also allow guidance from all our other Pacific Island countries that also have implemented a similar or other laws in terms of pandemic or health emergency, and they can also guide us going forward. So it's a very tricky area that we are faced with now in terms of whether we continue using the state of emergency law going forward, which doesn't really specify disease outbreak, but just because it's confined under the Constitution, it limits specific rights to people as well, or we will move to the Public Health Act as of December 31st, and then we will start issuing regulatory orders to agencies to confine the disease or to control the pandemic in the event that we have community transmission or sporadic cases. So I think I will leave it as that unless my colleague have any few remarks to add. Yeah, so that's basically where we are now. It's the struggle of power between the SOE and the public health emergency. Even though we declare a public health emergency, whether the public health emergency has more powers to control agencies like the police, the airports, yes, even though the minister under the act has regulatory orders that he can issue, we have tried it and it seems to be more people, I can say more people believe that the Constitution is the one that can make decisions to control people in a certain way or control situation in country compared to the Public Health Act. So it's a tricky area as we are exploring it going forward, but any guidance and comments from all our family and friends in the Pacific can also guide us in terms of whether for the ministry we move to the public health emergency or we stick to the state of emergency under the NDMO, which is affiliated with the Constitution. I think I will leave it as that, and if there is any comments or questions, we can ask it. Thank you, Jenny.
Thank you so much, Dr. Tapo. And I think that you've really neatly encapsulated three of the issues that so many countries are grappling with. And I think you've done it in a really clear way. So one of them would be the importance of a use of a multi-sectoral mechanism. So your National Disaster Office and your National Disaster Act, and the importance of bringing in all of those relevant sectors. And you seem to be describing a mechanism that worked there. But then there's the issue of lines of authority and lines of accountability when you shift your use of law from one relevant law to another as a risk escalates, and then as the risk starts to reduce again, different powers might be needed and different criteria trigger different uses of law, and you are working as best you can through how those laws might be used together, and also laws that were drafted in Vanuatu, as they were in so many countries, probably without a pandemic of this kind of scale in mind. And the third one was, what are the limits of the available power, and how do you manage, say, under the Public Health Act, and what the available limits of the power are, and whether you harness powers under other laws, and how all of those fit together. So I think that you've really neatly and helpfully, I think, outlined a lot of issues that are shared across many countries, certainly in the Pacific, but also more broadly throughout the region. So thank you very much. And we'll wait again until the end. I'm sure that there'll be questions, but I'd like to move on now to introduce Ms. Manti Charlton, and over to you, Ms. Charlton.
Thank you and good morning. I'll be focusing on Australia's Biosecurity Act 2015 today and the ways in which we have used that piece of legislation to support Australia's COVID-19 response. So moving to the next slide, the Biosecurity Act commenced on the 16th of June 2016. So it is really quite new legislation, and it replaces the Quarantine Act, which was in effect for over 100 years. And you can imagine that being a 100-year-old piece of legislation, it was written at a time where we did not have international air travel at all, and we did not have the speed of travel that we currently have today. So a very different sort of context. So our new legislation, the Biosecurity Act, was developed with that in mind. And it has a One Health approach in that we jointly administer that within the Department of Health and also with our Department of Agriculture, Water and the Environment. So being a new piece of legislation, it was the first opportunity to test a lot of our powers throughout the COVID-19 pandemic, and we've used just about everything in the book there in responding to this public health threat. There are a number of limitations within the Biosecurity Act that ensure that we're appropriately using that legislation, including a requirement that there's a strong public health rationale to be able to use those powers, and some specific principles of general protection outlined within the legislation itself. Moving to the next slide. And this is a little bit of additional context too of the Australian environment. We have 3 levels of government. So the Biosecurity Act is at that first level, the federal government, and our state and territory governments have primary responsibility for public health, including Australia's quarantine requirements. So our Biosecurity Act has primarily been used in developing and implementing national policies and requirements, including specifically at international borders. Our Biosecurity Act is used both for business as usual purposes, so outside of the COVID-19 pandemic, and you can see a few examples of where we use those powers in that first box there, but it also gives effect to some of our requirements under the international health regulations, including ship sanitation, vector monitoring at points of entry, and those sorts of things. It is used for pre-arrival reporting, which is one of the most important things in terms of being able to early identify a public health threat on board an incoming aircraft or vessel. We also have a range of emergency powers, which we've used for the pandemic, as I've mentioned, and some of those are outlined in that second box. So I'll go into a little bit more detail in the next slide, but you can see there's a range there of different powers that we've used, particularly at international borders, to be able to address those public health threats. So this is a bit of a depiction of the consultation processes and the considerations that we must use when we're using those emergency powers. So you saw on the previous slide some of the examples of the things we've done, but this really steps out that kind of process that we need to go through when considering it. And that first step is actually making sure that the disease that we're wanting to use the powers in relation to is specified under our legislation. And those diseases are really quite serious diseases that don't have endemic transmission. So we're thinking about pandemic influenza, obviously pandemic potential coronaviruses, those sorts of really serious diseases that we don't have within Australia and that we are looking to keep out. As an island nation, Australia does have a good advantage in that we don't have land borders. So if we don't have the disease enter Australia, then there's not an opportunity for it to transmit within our population. So that's that first step there, is making sure that it is a disease of concern specifically legislated under that act for us to be able to use those powers. In the second step, and this was our first time doing so, we can declare a human biosecurity emergency period. And to do that, we need our Governor General to be able to make that declaration. It's a legal instrument based on advice from the Health Minister. And the Health Minister forms that opinion based on the extensive health committees and experts that we use within Australia for all of our public health decision-making processes. So that declaration was made in March 2020 and remains in place now. It's currently in place until the 17th of December, but the government is considering whether it is necessary to have a future extension of that period, and we can only extend it by 3 months at a time. So that's one of those mechanisms to make sure that we're not using powers inappropriately and that they're proportionate to the public health risk. In step 3, you can see that the Health Minister can make any requirements necessary to meet the public health risk once an emergency is declared. So the Health Minister has exercised these powers, I think, 8 times in total during the pandemic for different issues, but some of those different emergency determinations have been amended a number of times as needed to meet the different kind of changing context. And once again, we use our specialist and expertise committees across the sort of federal and subnational government levels to be able to inform that decision-making process so that we're getting the right public health rationale and advice to be able to support the decision-making. And part of the intent is that we're not just providing ministers with powers to do things, that they actually do need to be using those professional clinical judgments to be able to exercise them. So as I mentioned at step 4, the human biosecurity emergency period can only be in place for 3 months at a time, but we can extend it. And we have done that a number of times since its first implementation in March 2020. But there will be a point in time in the future where we no longer have those emergency powers. And one of the things that we're internally considering is what that means for the emergency determinations we have in place now, and whether we still want to be giving effect to those restrictions and requirements through other settings, including other legal instruments or other policy options. In responding to the future needs of the COVID-19 pandemic, and as I've outlined, this is the first time that we've used a range of these powers. So it is a real opportunity for us to be able to learn what they look like in practice. We have prepared for this pandemic in that we've written policies and work instructions and guidance materials, but nothing is quite like actually doing it in practice. So we have a lot of things that we have learnt through implementing these powers that could be improved or could be better done. And we're keeping a track of all of these so that once the initial pandemic response and the initial need is over, we can continue to review these and have a continuous improvement process underway. Our joint external evaluation in 2017 did positively reflect on our legislative framework, but as I've mentioned, in actually using the powers, we've discovered things that weren't picked up in the JEE, and it would only really be picked up during an actual use of the power itself. So I mentioned that we're keeping an internal register of these lessons and these opportunities for improvement, but we all are also amending things as we go along if there is an immediate and pressing need. And one of these amendments is before the Australian Parliament at the moment, and that's the Biosecurity Amendment Enhanced Risk Management Bill. And that bill is specifically looking at the risks posed by cruise vessels. So one of the biggest outbreaks in Australia early in the pandemic was the result of a cruise vessel entering Sydney Harbour with hundreds of cases on board, and those people then went into the Australian community and also travelled internationally. So we've used that lesson to implement some improvements in how we might have additional pre-arrival reporting requirements for cruise vessels, increasing the penalty provisions for the people who don't comply with some of these requirements. So if a vessel wasn't to meet the Australian government requirements, that we can apply a bigger fine to them, and also to provide some new opportunities to be able to direct groups of people differently. We are also, I suppose, fortunate enough that we are being audited independently by the Australian National Audit Office. And those audits are a really good objective way of identifying where there's additional lessons or improvements that could be made, not so much in the legislation itself, but in the consultation and the implementation of that legislation. So obviously, no department can do everything themselves, and we do rely quite a lot on our other government agencies, including those that have a physical presence at international borders, such as the Australian Border Force and our Department of Agriculture colleagues. So where we might have opportunities to strengthen our relationship with those agencies. I might talk a little bit briefly about the different mechanisms that we have used these emergency powers for. And I mentioned cruise ships. Cruise ships in Australia are currently prohibited from entering the Australian waters. They're not able to operate within Australia if there's more than 100 passengers on board. And a lot of real strong restrictions on that. And that's because of that first experience with that vessel and the potential for cruise vessels to have a large number of cases on board. And we don't want, there to be an outbreak on board and then entering that Australian community context. But at some point in the future, particularly with Australia's vaccination coverage increasing quite strongly, we will be looking to remove those restrictions. Also, one of the Australian government restrictions is on outbound travel of Australians. And this has been quite a controversial one, and not one that a lot of other countries have used. But as I mentioned, as an island nation, Australia has got an opportunity that countries with land borders don't necessarily have, in that we can really strongly control the entry and exit of diseases through controlling those sorts of international movements. So since March 2020, Australians have been restricted from leaving the country unless they have an exemption or they fit in a very specific category. And on the 1st of November, we made our first steps towards removing these restrictions by allowing fully vaccinated Australians to leave without getting an exemption. So we are continuing to restrict the movements of unvaccinated Australians, both to protect the Australian community when these people are returning, but also to protect those people who are at higher risk of themselves contracting COVID. And probably the main other one I'll mention is our pre-departure testing requirements. Like many countries, Australia does have a requirement that travellers to Australia provide a negative PCR test within 3 days of departure to come to Australia, and that's sitting under our emergency powers. But that's one of those mechanisms that we are wanting to consider an enduring process for, because it is something that we do see as being important into the future, whereas things like cruise ship movements and the outbound movement of Australians are things that we do know that we are going to be looking to reduce and ease those restrictions in the near future. So I think that will do with that for me. Thank you. Happy to answer questions when we get to question time.
Thanks so much, Ms. Charlton. And it's been really interesting. This is the third country experience that we've just heard about, and so interesting to hear how different they are, and yet some areas of similar challenge as well. Just noting a few things there that I thought were of particular interest. The One Health approach, which I think is and the co-administration by a number of sectors, I think is very much worthy of note. Also noting that of the available powers that were put in place pre-COVID, that you've used almost every available area of power. Again, very interesting. Noting also the need to review in real time, and probably at the end of the COVID as well. And so many countries, I think, will be similarly thinking about how their laws went and how they might review them towards the end and at the end of the COVID pandemic, and also noting in that respect as well the importance of accountability, and in this case the Department of Audit that also provides that accountability. So thank you very much. Now we'll move on to Dr. Liu Yang, and over to you, Dr. Yang.
Good morning, good afternoon, good evening, every colleague. I'm Liu Yang from the Legal Department of National Health Commission of China, and very glad to have this opportunity to introduce you how China did on the basis of law to make measures to control the COVID-19. And COVID-19 is a global pandemic, is the most extensive to afflict humanity in a century. And facing this unknown, unexpected, and devastating disease, China launched a resolution battle to prevent and control its spread. Making people's lives and health its first priority, China adopted extensive and thorough containment measures. And in the past decades, China has made many laws relevant to public health. For example, we have national statutes such as Emergency Response Law, Law on Prevention and Treatment of Infectious Disease, Law of Frontier Health and Quarantine. And we also have administrative regulations such as Regulation on Response to Public Health Emergencies. And we have administrative rules such as rules on Law on Prevention and Treatment of Infectious Disease. And we have policy documents made by the State Council or the government agencies, like measures on public emergency management plan. And there are local regulations and rules as well. All the laws and regulations strengthened legal safeguards for the epidemic prevention and control. During COVID-19, China took measures to control and prevent epidemic on the legal basis. For example, according to the Law on Prevention and Treatment of Infectious Disease, the infectious diseases are divided into Class A, B, and C. And the law provides different control and treatment measures for different classes of infectious disease. In the last year, China listed COVID-19 as a Class B infectious disease and addressed it with measures applicable to a Class A infectious disease under the Law on Prevention and Treatment of Infectious Disease. And it also applied control and quarantine measures under the Frontier Health and Quarantine Law, consistent with relevant provisions and international law and other domestic laws. The standing committees of some subnational people's congresses, like the congresses of different provinces, they launched emergency legislation procedure as per the national legal framework, empowering local governments to introduce interim emergency administrative rules relating to healthcare and epidemic control. And the law on prevention and treatment of infectious disease and measures for its implementation have been strictly enforced. And the guidelines have been made on controlling the disease, combating epidemic-related crimes in accordance with the law, and protecting people's life and health. Law and order and market supervision have been strengthened, and stronger measures have been taken against deceptive and illegal advertising, ensuring social order and stability. And the supervision on administrative law enforcement have been intensified during epidemic control to ensure that the law is enforced in a strict, impartial, procedure-based, and non-abusive way. Legal disputes associated with the epidemic have been resolved in accordance with the law, and legal guarantees and services have been provided for COVID-19 response and for business returning to work. And the government has also made greater efforts to raise the public legal awareness and guide people to act within the parameter of law. And listing COVID-19 as a Class B infectious disease and address it with measures applicable to Class A infectious disease under the law, provide legal basis to take strong legal measures to control sources of infections. According to the law on prevention and treatment of infectious disease, the Chinese government defined a set of requirements: early detection, reporting, quarantine, and treatment, with a focus on 4 categories of vulnerable people, like the confirmed cases, suspected cases, febrile patients who might be carriers, and close contacts. It had also taken measures to ensure that they were hospitalized, treated, tested, and quarantined as appropriate. It has done everything in its power to reduce infections to the minimum. And China has provided information on COVID-19 in a thoroughly professional and efficient way. It has released authoritative and detailed information as early as possible on a regular basis, and thus effectively responding to public concern and building public consensus. And a strict system of information release have been established according to law on prevention and treatment of infectious disease. China has released information on COVID-19 in a timely, open, and transparent manner as required by law, and strict regulations are in place to see there is no withholding of information or delay in reporting cases of infections. China has shared information and experience with the international community, and China has provided support for global virus prevention and control by sharing information and experience with the international community. And now China is improving the legal safeguard for public health. And the Standing Committee of National People's Congress worked to establish stronger legal safeguard for public health, and developed a work plan for enacting new laws and revising existing laws in a timely manner, and formed the task forces to advance the enactment or revision of 30 pieces of legislation in batches. Like we are going to formulate the law on responding to public health emergencies, and we are revising the wildlife protection law, the law on prevention and control of infectious disease, the frontier health and quarantine law, and the practicing physician law. Responding to the sudden outbreak of COVID-19, we focused on developing a better coordinated and interconnected legal system and speed up the enactment and revision of laws to strengthen the rule of law with regard to public health. By improving relevant laws, raising legal awareness, and promoting greater compliance, we worked to ensure that the release of information on COVID-19, the allocation of emergency supplies, the handling of social issues and disputes, and the maintenance of order in the market were all carried out in coordination with the law, and thus using the force of law to protect the health and safety of our people. And in the future, we call on to build an efficient and sustainable global public health system for the benefits of all humanity. And China therefore calls on the international community to draw lessons from this pandemic, and the countries should show extraordinary political vision and a strong sense of responsibility by doing following things like embrace a philosophy that puts life above everything, and establish sound mechanism for international cooperation, and create an efficient, sustainable global public health system for all, and build a global community of health for all. And this is my presentation. Thank you.
Thank you so much, Doctor. That was very comprehensive and very helpful. And I just noticed a number of really interesting points that you made that I think enrich our conversation greatly. So noted the extensive laws that China had passed in relation to the management of public health risk and health emergencies. I noted your helpful description of the classification of infectious diseases into different classes, and a lot of countries have those kinds of things, and I think very helpful during COVID-19 to be able to trigger the various measures that were needed to be taken. Also, there was a very important point I thought that that needed to be made about the importance of the different functions of the national and subnational levels of government and the use of law at those different levels. And obviously China is a very big country, and the use of laws at the subnational level would have been very important. Noting also what you said about the management of communication and its importance, and the use of protections also around the use of law. So also very important. Noting what you said also about the efforts that the government made to let people know what was happening. Certainly, we've noted as we've been moving through this pandemic and communicating with countries that a lot of countries struggled sometimes to get information out to people to understand what was happening and why. So noting that the Chinese government tried very hard to achieve this. Also noting the importance of regular updates, and also that that China's already working to review existing law. I think a lot of countries, I think we said after some of the other presenters, a lot of countries are reviewing and monitoring the use of law during COVID-19, and we'll think about it again afterwards. And also noting China's calling on countries generally to learn lessons from the pandemic, and I think that very timely communication, and I think definitely what we are trying to do in relation to this forum. So Dr. Yang, I want to thank you very much for your intervention, and then we'll move on to Mr. Fazu, and just noting that we're running a little bit behind time, so we'll be most grateful, Mr. Fazu, if you can try to stick to time. Thank you.
So I guess I would just like to say thank you very much for the wonderful discussions today, and definitely it's been great to hear from everyone on the work that they have been doing with regards to response to COVID, and perhaps also reinforce some of the messaging from from the foundational work that was done earlier on with regards to response to disasters. And I think listening to the countries, I just wanted to touch again on some of the similarities or some of the issues that are common with regards to COVID-19 and other disasters that has been experienced in the region. As you may be aware, the Pacific is home to a number of hazards, and with climate change, there's a lot of issues that, or a lot of disasters that they have been exposed to. Give you a little bit of a snapshot. Since 2012 to 2016, Vanuatu and Tonga have been first and second as the most vulnerable countries in the world to disasters. In 2019, Tonga slipped down to 3, while Vanuatu maintained first. In 2020, Vanuatu and Tonga became first and second again. And this year, 2021, Vanuatu is the first, Solomon Islands is the second, and Tonga is the third. And what I'm trying to emphasize here is because of the rich history of responding to disasters in the Pacific region, there have been lessons learned over time that can translate across to a lot of disasters. Although, as from the discussions that we've had today, not totally applicable to all types of disasters or addressing all types of emergencies. There are some constants there that you normally take into consideration in times of response. Yes, so I mean, just looking at disaster law in general, I think it was emphasized earlier on that you need to ensure that our laws and what's in place address legal preparedness. And this is for regulation of international assistance, looking at across a sectoral approach. And of course, in the beginning, climate change and DRM was one of the key themes in the Pacific until COVID-19 came in, and then the public health emergency became, I guess, one of the issues that everyone was turning to. So risk reduction across all sectors, no matter what type of hazard or disaster you're looking at dealing with, is something that needs to be addressed in all types of emergency and disaster laws. And of course, as pointed out by our presenters today, knowing your rights and especially the roles and responsibilities that each and every one has to play in times of disasters. These, as you see before you, are some of the studies that have been undertaken to support a number of these developments in the region as well as in the world. And a new one there is the Law on Public Health Emergencies study, which was just conducted during COVID-19 time. And we would like to thank WHO for their participation in the international launch and launch in Asia. And of course, we're hoping to also launch together in the Pacific in the coming weeks. I guess one of the key things that we realize here, and just like the disaster laws themselves, is that a number of the laws and policies that we have in place are a bit dated. And there is a need, I guess, to move on in terms of reform. And that is something that I realize we have all agreed on with regards to moving this work forward. As identified, there's not really a lot of international treaties or agreements that comprehensively look at disasters or regulation of emergencies, other than international humanitarian laws, the health regulations, as we've been discussing today, and the refugee laws. However, there are sectoral legislation, and this comes out in a number of discussions that we've had today, that we need to kind of like coordinate across sectors to take an integrated approach for a successful response. So for instance, in a lot of the discussions that we've had today, there have been discussions with regards to the involvement of customs at the border. And of course, at the international level, you would have the Kyoto Convention, the revised Kyoto Convention, Annex J5, which provides for the clearance of disaster relief in times of disasters, and then the types of concessions and exemptions that are provided. The Tampere Convention with regards to looking at dedicated telecommunication, allowing comms equipment to be brought into the country and to be used. The Food Assistance Convention, which provides that the basket that is provided in times of disasters have to be ensured not to be empty calories and have to have a certain nutritious content. And in the Pacific, the key things that occurred due to the fact that geographic nature in the Pacific being maritime, looking at the Chicago Convention and of course the Convention on Maritime, the movement of goods across the oceans and into the Pacific. So another IDR checklist, and I guess this is an area where a number of you may have also dealt with in work in the region, is just looking at with the close downs, and this is because of the Spanish flu that occurred in the Pacific, the rich history of the Pacific and pandemics, and I guess out of that, more than 20% of the population in Samoa were decimated. And during the time of the pandemic, when COVID was starting to emerge, Samoa had also undergone, I guess, an epidemic of measles. So there was around the region also outbreaks of measles, and there was a lot of wariness within the region with regards to a pandemic or infectious diseases. So when COVID-19 started emerging, you will notice that a lot of the Pacific Island countries, and this is after an assessment of their health regulations and their health laws, they actually shut their borders as a way of minimizing the risk and as a way of ensuring that they are not affected. And because of that, there was not as much, I guess, badly effect in the countries in terms of the disease itself or the pandemic itself, except for, of course, those whose borders were open, as we heard from PNG. But there were other effects and there were other problems. And this is something that came out in some of the discussions that we've had, including the presentation from our colleagues in Vanuatu. And these issues would be economic issues. And there were also issues of, because of the lockdowns, there was an issue of immobility, and there were a number of people who were then stranded. And this is where I guess the importance of looking at an integrated approach with regards to disasters is required, so that we can all come together in the different sectors and assist each other. I guess we all agree that there is a need to improve our laws, both in the health sector and as identified also, disaster risk management laws, and then the laws with regards to emergency declarations, and as identified by our colleague from PNG. This is where there needs to be a closer look at what powers you are using. And because of the strict requirements on the use of emergency powers under the Constitution, and because of the effect it has on human rights, as pointed out by our PNG colleagues, the term for that particular declaration is a bit limited. However, if you have alternative, I guess, laws in place for other declarations, as pointed out by our colleague in Vanuatu, then the extension can be a bit wider. And this is where I guess, thank you. I noticed that my time is almost up.
Yeah.
But I guess to finish off, I just wanted to say that the approach given by a number of the countries shows that there is a need for us to come back together again and to look at a better way of moving things forward. An integrated approach is required, and integration here doesn't have to be under one legislation. It's just having a cross-sectoral understanding of the roles and responsibilities in protecting the country, in protecting your borders, and also looking at the approaches that were put in place that can be used again in the future, like Cook Islands having a sunset clause and the law they put in place as a placeholder until COVID-19 passes, or a better law, well-drafted law is brought out. But a great approach here is the approach that was given by Australia as well, very comprehensive, setting up the powers. And of course, you have those powers under your customs laws. So if you don't have that act in place, you have those laws through a sectoral approach that you can utilize in the time being while you're working out more with regards to quarantining people who arrive in on a ship. Apologies, the time is quite short. It's a very, very great discussion, and I'm elated to be here and to learn from everyone. Thank you very much, Genevieve.
Thank you so much, Mr. Fazo. And I can see how you tried so hard to fit as much as you could into the available time, as everybody did, I must say. And I am grateful to all of you. Just in relation to what you just said. I think it was really helpful at the end of a session like that to bring us back to the perspective of disaster risk management and to look at it also from a regional perspective, and noting also what you said about the importance of assisting in each other. And of course, you're right. And also you made the point quite rightly and echoed some of the thoughts from our colleague from Papua New Guinea about the importance of those disaster management laws connecting back to the Constitution and being the importance of them fitting within the parameters set by constitutions and the oversight in relation to powers that are so broad within the community. Now, we are going to allow 10 minutes for questions. We have gone well over time, and my sincere apologies to everybody for that, but we did want to allow at least a little bit of time. So if anybody has a question, please put your hand up within the, using the reaction section in Zoom, and I'll just look to see whether there are any hands. All right, well, if there aren't questions, I think that that we can wrap up. It's been an incredibly detailed and I think incredibly useful session, and I've been enormously grateful for the contribution of each of our expert panelists, and I want to thank you very, very sincerely for that, for giving your time to us today, and to join with your colleagues in the region for that purpose. So I think I'll pass it back to you, Jonathan, and you can take it from here. Over.
Genevieve, I did see a hand go up.
Thanks, Jonathan. I raised a hand and then realized let's discuss. But my question to a presenter from IFRC and China is, if I need to understand what are three major strengths and major weakness, which the communities in Asia and Pacific would learn from experience in China and IFRC experience in the Pacific, would be good to discuss.
Thank you, Genevieve. Would you like me to go first?
Please go ahead. The question was to you, I believe.
Yes. So I guess as we tried to point out, with all disasters, there has been ongoing capacity building within the region. And with the cyclone season coming up here in the South Pacific, there has been a lot of training going on to build the capacity of the communities in response in case of a cyclone occurring. With COVID-19, of course, that brings a lot of other, elements to it as well. And that includes putting in place a SOP for how you respond to a disaster while there's a lockdown or there is a community case. So as mentioned before, there is a lot of best practices that we can build on, those linkages from the national down to the subnational and right down to the community level. So that linkage is through your national society, Red Cross, Red Crescent branches in terms of building that capacity, and then building on that and adding the other requirements that you have. You already have requirements there with regards, because you normally after disaster, you would have other outbreak of diseases or vector diseases. So you have best practices already there under WASH protocols for how to wash your hands, how to sanitize, and how to treat water before you consume in times of disasters. So it's building on those experiences and what's there, to adding on and tweaking it in relation to the best standards or what comes out of the WHO advisory in terms of increasing, diligence with regards to those already in place SOPs, and tweaking that to address the new emerging issues when it comes to disease outbreaks. I hope that kind of answers the question. And here again, it's the capacity building, it's the tools, it's something that continues and is ongoing, both in post-disaster as well as in the preparedness phase. Thank you.
Terrific, thank you so much. And unless I've missed any more hands, I can't see any, I'll hand over to you now, Jonathan. Thank you so much.
Okay, thanks very much, Genevieve, and to all our panelists for a fantastic session. We're going to take the 15-minute break now, and so we'll return at what will be 11:40 Manila time for session 3, which is on digital technologies in the COVID-19 response. So thanks so much, everybody, for a great session, and see you back here in 15 minutes.